Intellectual property, as you will read this unit, is a concept that was conceived hundreds of years ago. Copyright, the right of the creator to control the products they create, is just one of the doctrines categorized as intellectual property rights. As you will later see, intellectual property also refers to patents, trademarks, and trade secrets. In this module, we'll learn about the basis of intellectual property rights and why they exist. This will also include a look at how the laws are made and how disputes around IP are settled in the court system. We're also going to take a look at the Founding Fathers. Those are the people who included the Copyright Clause, as it has come to be known, into the Constitution and how they felt regarding regulating intellectual property. So, what's the purpose of copyright? Most people believe that the purpose is to give authors and artists credit for their work and give them the right to protect these works from others who want to steal them without paying. But as you will learn, that's never been the case. As the History of IP article from the National Paralegal College explains, laws regarding intellectual property existed hundreds of years before the U.S. was founded. The purpose of the laws at that point in time, however, greatly differed from the purpose of IP laws when the U.S. was founded. As you will read, the purpose of copyright law, according to the Copyright Clause, which is in the Constitution, was to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries from the Constitution. The inclusion of this clause in the Constitution is the basis for all copyright and intellectual protection today. Obviously, however, the Founding Fathers lived in an entirely different world. Think about it. Very little printing, no internet, no digital anything. You might be wondering how something that was written in the late 1700s could possibly apply to today's world. Therein lies the complexity of IP. The printing press was invented by Gutenberg around 1440. This invention was phenomenal because prior to that, the only books that existed were hand-copied by monks. It was a laborious process that was controlled by the religious establishments at the time. As you can imagine, controlling the ability to create and distribute printed materials was a great source of power. This was easily controlled when the monks were hand-copying books. But once the printing press was invented, anyone who had a printing press could reproduce political and religious ideologies. Governments were not happy with losing the power to control what was printed and distributed. The laws during the 1500s were meant to concentrate the power to disseminate ideas that might be contrary to the current government or the religion in power. You will read about the various laws that were developed in England at that time. When the colonists created their own laws, each colony passed its own intellectual property laws. You're also going to read how this was detrimental to the value of actual IP. After all, if I'm an author and my book only has protection in the state of Pennsylvania, anyone could reproduce the book freely in New York. This gives me, as the author, very little protection. The Founding Fathers realized that intellectual property was one of the things that was going to need to be regulated at a federal level to be effective. The Founding Fathers, the men who were writing the Constitution, knew that they had to do something to regulate intellectual property in order to make a strong, economically sound country. However, they did not all feel the same way about government intervention in citizens' lives. Remember, they left England to escape government control of daily life. They were fearful of monopolies too, and copyright was akin to a monopoly on, at that time, books and printing. Noah Webster, yes, the Webster dictionary guy, as well as some other individuals, had been pressing the states to create copyright protection because obviously it had to do with commerce. The clause for copyright, however, was not in the first draft of the Constitution, but shortly thereafter James Madison proposed it. It was added without much debate at that time because the debate had already occurred. Please refer to the reading What the Founding Fathers Thought for more on this development. In the end, they realized that strong intellectual property laws were needed for commerce and progress to occur. Thus, the specific wording of the source of IP power in the Constitution. Your textbook does an excellent job of describing several justifications for copyright, namely the economic basis, incentive to create, property theories, and philosophical justifications such as personality theories and natural rights theories. It's important to remember that intellectual property protects creations of the human mind. There are four basic types of intellectual property. The rights bestowed to the creator of the IP are the exclusive right to use, in the case of trademarks and trade secrets, and reproduce, in the case of copyrights and patents. This semester you're going to learn about four IP types with an emphasis on copyright, as it is the most applicable to technical writing and communication. Copyright consists more than just the right to reproduce something. In what is referred to as a bundle of rights, the copyright owner is entitled to publicly perform the work, distribute the work, create derivative works, control the public display of the work, all in addition to the right to copy the work. Patents are similar to copyright as they both prevent others from reproducing a creation. However, patents also prevent other people from using the creation, importing the creation from other countries, or selling the creation without their permission. When something is trademarked, others are prevented from using the creation. Consider the Nike swoosh, for example, or the Coca-Cola logo. Only the owner of the trademark is able to use the creation. Similarly, trade secrets prevent others from using the trade secrets that a company has. Because the federal government was given the sole right to regulate IP, as evidenced by the copyright clause in the Constitution, statutes and regulations applicable to IP are created by the federal government and regulated by federal courts and agencies. States have not been given the authority by the Constitution to regulate the IP within their borders. The sole grantee of this right are federal courts, federal agencies, and federal rulemaking bodies. You'll see trademark laws concentrated in Chapter 22 of Title 15 of the U.S. Code. Copyright is Title 17, and patent law is Title 35. There are also two federal administrative agencies that play a role in the regulation of copyright and patents. The first is the United States Patent and Trademark Office. They create the procedures under which patents are granted. They decide if a specific patent is approved or not. And the United States Copyright Office, which is a branch of the Library of Congress, which is responsible for keeping a copy of every work that is registered with the department, for providing information to the public about copyrighted work, and for evaluating every submission to determine if it's eligible for copyright protection. You'll also learn about another type of law that is not statute or a regulation. This is case law. Case law is founded on the principle of stare decisis, a Latin term that means stand by things decided. Case law are the precedents, the decisions that have been made by previous court rulings. That means the courts will follow or at least consider higher courts' previous decisions on cases. Case law is the reason you will see many cases referring to previously decided cases as their justification or rationale. Not just any court's ruling has this power, however. Only the 13 federal circuit courts of appeal, which reconsider decisions made by the federal district courts, and the U.S. Supreme Court, which reconsiders decisions made by the appeal courts, create case law. So the lower court would look to case law created by the higher court's decisions. Federal circuit courts of appeals look to supreme case law. They do not look to district court cases. District courts use precedents from the Supreme Court and the Federal Circuit Courts of Appeal. There are no courts that look to the district court case law to make their decision. A losing party can file for an appeal to the Federal Circuit Courts of Appeals on the grounds that the judge applied the wrong law, or that the case hearing was conducted unfairly, or that the law was not applied correctly. All those that petition the Federal Circuit Courts of Appeals will have their case heard. This is not the case with the Supreme Court. The Supreme Court is allowed to select the cases they would like to hear. Approximately 7,000 petitions are made to the Supreme Court each year. They select only about 100 of the cases they want to hear. So, for the vast majority of the cases, 99%, the Circuit Court of Appeals decision will stand. The other 1% of the cases make it further. For Americans, however, IP protection is needed across the globe. We now live in a global marketplace, and it's important to understand that the laws made in the U.S. do not have to be honored by foreign countries. The issues that this causes are very similar to those as when each state had their own IP laws. Without widespread acceptance of a person's ownership rights to the IP, the right's not worth very much. Governments realized this and attempted to remediate the issue through the creation of treaties. Treaties are agreements entered into by federal governments. In the U.S., it's agreed to by the President and ratified by the Senate. It also provides another source of intellectual property law. The Paris Convention, the Berne Convention, and the WIPO Copyright Treaty are examples of such treaties. The rights afforded to Americans for their IP abroad are controlled by these treaties only in the countries that are signatory to them. The map shows signatories to the Berne Convention. You can see that the vast majority of countries, as represented in the color gray, are signatory to Berne. You'll soon see the complexities of intellectual property law as you're reviewing the course readings. I just want to warn you to not be alarmed by the volume of these complexities and the seemingly endless gray areas. That is intellectual property law in America.